Welcome to Connections, the Arab Studies Institute interview program. I'm Mouin Rabbani, and this evening I'll be hosting the first of four special episodes about the International Court of Justice hearings on genocide in the Gaza Strip. On Thursday, the 11th of January, the International Court of Justice in The Hague begins consideration of a case submitted by the Republic of South Africa accusing Israel of committing genocide against the Palestinian people. It is a case that has been described as historic and also as one that is unlikely to change anything. This evening, and at the same time for the next three evenings, Connections will be devoted to discussion and analysis of this case. I'm delighted to be joined on each of these evenings by the world-renowned forensic scholar and best-selling author Norman Finkelstein. He counts among his numerous publications the highly acclaimed Gaza, an Inquest into Its Martyrdom. Today, we will provide an overview and preview of the case. Tomorrow, we will discuss the case presented by South Africa. Friday, we consider Israel's response. And in the final installment, on Saturday, we will review the hearings and discuss where the case goes from here. Norman Finkelstein, it's a real pleasure to welcome you, or rather to welcome you once again to Connections.
Well, thank you for having me. We can dispense with the formalities because Mouin Rabbani is an old friend, and we first met as a consequence of the Israel-Palestine conflict. So in many ways, this is a moment for both of us after a lifetime's commitment to trying to achieve justice.
Thank you, Norm. So during the next hour, I'd like to basically review the case. What is it? How will it be structured? What is happening in the current phase? The extent to which it is or is not significant, and a preview to what we can expect to hear tomorrow. So starting with the most basic of elements, what is the International Court of Justice? What is genocide? What is a genocide convention? And why is South Africa, which is not claiming to be in any way a victim of Israeli conduct in this case, why is it the Republic of South Africa that is bringing the case? And what is its claims and what are Israel's counterclaims? Would you like to start with that?
Well, that's a long order. Maybe we'll, because my memory isn't perfect in recent days, recent months. So maybe we'll just start with the first question, if you don't mind, both for myself and for your listeners, just to repeat the questions one by one, and then we'll go through them. And I can't claim to complete expertise in every area, so we should do it back and forth and build on each other.
Well, perhaps starting with a brief introduction to the International Court of Justice. It's been described as the supreme judicial authority in the world. It's an agency, in effect, of the United Nations, and its purpose is to adjudicate disputes between states, unlike the International Criminal Court, which investigates the criminal responsibility of individuals. Are there any additional aspects regarding the role and mandate of the ICJ that you would like to bring into this discussion?
Yeah, I will just mention several features. First of all, it's the official judicial body of the United Nations. And that's a significant fact for the following reason. One of the podcasters, Crystal Ball, who I watch, she made the important point that if you read the South African submission, it relies very heavily on UN reports and UN organizations. And that's actually, it didn't occur to me until I heard Crystal Ball say that. That's actually a significant fact. Because it's the judicial body of the United Nations, it would be very hard for the ICJ, the International Court of Justice, it would be very hard for the ICJ to rebuff all of these UN officials and all of these UN organizations which have made a voluminous number of statements since October 7th, attesting to the horror that's unfolding in Gaza. So I think it's important to bear in mind that this is the official UN judicial arm of the United Nations, and then juxtapose that with the extent to which the South African submission is dependent on the testimonies and the findings of the various UN organizations, beginning with the Secretary General. Mm-hmm. The Secretary General of the UN says Gaza has been turned into a graveyard for children. That is a very tough statement for the ICJ judges to ignore.
Precisely because it's coming
from a UN official.
Yes,
it's coming from the Secretary General.
And we'll get into more detail on the South African submission later in this discussion. But
I want to just make one other point, that the ICJ doesn't just issue decisions in disputes. It also issues what are called advisory opinions. And advisory opinions have a different status than disputes. An advisory opinion is when the ICJ simply renders a legal judgment on a question that's been put to it by member states of the General Assembly. And it happens that the ICJ did already deliver an advisory opinion on the status of the wall that Israel had been building.
In 2004.
Yes, in July 2004. And that opinion was completely ignored by Israel. However, this will be a slightly different case because they're adjudicating a dispute, and Israel will be legally bound to accept the verdict rendered by the ICJ in this dispute. They weren't legally bound by the advisory opinion. It has a different legal status. So this is of a higher order.
We can consider it akin to a lawsuit brought by one state against another, and the ICJ is adjudicating it and finding a guilty party, so to speak.
Exactly.
So, without getting into
I want to just make one last point, because people get very confused on this. So we should just try to assist listeners. There are two international bodies. One is called the International Court of Justice. The abbreviation is ICJ. And then there is a second body called the International Criminal Court, and that abbreviation is ICC. So if your eyesight is beginning to fade, you have to look carefully. The ICJ is an altogether separate and distinct body from the ICC. The ICC is it's a body that countries can join, or states, a body that states can join and then hand over to the ICC, the International Criminal Court, jurisdiction over criminal issues of, I think it's war crimes, crimes against humanity, genocide,
and crimes of aggression.
And crimes of aggression. Yes. So just a warning to listeners, be attentive. Is it ICJ or ICC that people are talking about?
And the ICC, unlike the ICJ, is not a UN agency.
Correct.
Now, without getting into all the technical details, let's discuss genocide and the Genocide Convention. This case is being adjudicated pursuant to the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. As the date indicates, it was adopted shortly after the Second World War and the Holocaust. And it had very much as a purpose to not only punish the perpetration of genocide, as was done at the Nuremberg trials, for example, but also to actively prevent such crimes in the future. And what distinguishes genocide from, let's say, crimes against humanity is that what's key to being found guilty of genocide, it's not only what you do, perhaps even more important than what you do is why you do it. In other words, intent has to be proven. And if the defending state can plausibly argue that it committed these acts, these crimes, for any reason other than a deliberate attempt to destroy a group in whole or in part, then regardless of what that state actually did, it doesn't qualify as genocide. Is that correct?
Yes. However, I think remember, we're trying to bring knowledge collectively to listeners. So I think that the best way to begin is maybe you could just read that definition of genocide as it's in the convention. It's that first, famous sentence about "as such," in part or in whole, so people can hear the definition, and then we can have a
I'm looking it up
deliberation
because
over.
I don't have it handy.
It will take you a moment to bring it up,
Yes, here it is.
and just read, I think, Article 1.
Yep. Here we go. It's coming up.
Take your time. If people have tuned in, they will be patient.
So, Article 1. Okay, I have to. Okay, it's Article 2. Yes. Genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. And then
Okay, if you don't mind, again, for the sake of listeners who want to be prepared for the hearings, we should parse that language. So
yes,
maybe you can just start again, read it slowly, and I'll say stop, or
yeah,
you'll say stop, and we'll try to point out why each word is
yeah.
critical.
So genocide means any of the following acts committed with intent to destroy, in whole or in part.
Okay, so let's just start there.
Mhm.
With intent to destroy.
Mhm.
Now there's in the legal universe, obviously they quarrel over every word. I would say two things there strike me. First of all, it doesn't say to exterminate, it says to destroy. And destroy, in my opinion, is something short of to exterminate, because destroy can mean to disintegrate. Let's say you destroy a piece of paper by tearing it up, which is different than taking the piece of paper and throwing it into a fire, as I see it.
Mhm.
So throwing it into a fire would be like exterminating it.
Mhm.
But tearing it up, the parts are still there, but the paper has been destroyed. So I think there is a distinction. Some people have made that distinction, and I agree with it. You don't have to demonstrate that the goal was to exterminate, wipe out physically. You could say your goal is to destroy a people.
You can destroy a society and make
Yes,
continuation of that society untenable without necessarily exterminating the members of that society.
that's how I see it. And I know there are some people who interpret it that way, but I'm not claiming, so listeners don't say, no, that's not correct. I'm saying it's a plausible
Yeah.
interpretation.
Okay.
The
Within,
second, the
yeah.
second thing is it says in whole or in part.
Yes.
So somebody might make the argument, how could you call it genocide when there are all these Palestinians in the West Bank
Mhm.
and nobody's attacking the West Bank? So it can't be genocide. The answer there is, well, the people of Gaza are part of the Palestinian people. And since it says as a whole or in part, if your aim is to destroy the people of Gaza, it constitutes genocide, even as the Palestinians in the West Bank don't face at this moment that sort of existential threat. So the language anticipates that kind of argument. You know, you could have said to Hitler, well, he's not targeting the Jews in China, so it can't be genocide. Well, that's obviously on its face. It's literally true, but on its face, it doesn't
Absurd.
disqualify
Yeah.
it from being called a genocide.
Yeah. So, in whole or in part, a national, ethnical, racial, or religious group as such,
Okay,
meaning it's a crime based on the identity of the victim.
well, with some notable exceptions,
Mhm.
it doesn't say a political group.
Mhm.
And there was debate about that. Let's say Hitler wanted to wipe out all communists. He did. That was his, when he invaded Russia, the Operation Barbarossa, the first target were the communist cadres, okay? That does not constitute genocide under the convention. It has only 4 categories, if you can just repeat them.
National, ethnical, racial, or religious group as such.
Right. Notice it doesn't say in terms in our woke times, it doesn't include sexual group.
Mhm.
So the extermination of, let's say, homosexuals by Hitler, that wouldn't have qualified as genocide. Now you might say unfair, unwoke, yes, but it's also, that's what the law says. And then that final term, which I've always hated, the as such. Whenever a lawyer starts using as such too much, you know he's full of a word that sounds like such. As such simply means that your intent has to be to kill that group.
For no other reason
No
than
other
that they
reason.
are members of that group.
Yeah.
Yeah.
I think
So,
you should repeat that because that's an important point, if you don't mind reiterating it.
yes, you kill members of a particular group for no other reason than their membership in that group. In other words, you can't target them because of their political beliefs or because of for example, their sexual orientation or whatever. It has to be because they are Catholics or Chinese or whatever. It has to be with a specific intent to destroy members of that specific group.
Okay, so I'm going to put a question to you, Mouin, and I'm curious how you'll answer it. Let's say the Council for Israel, Malcolm Shaw, he says clearly this can't be called genocide because Israel is not targeting the people of Gaza as such. It's targeting them because of what they did on October 7th. So we're not, the intent is not to kill them because they're a racial group. The intent is to kill them because they committed that horrendous, horrific crime on October 7th. So it can't be called genocide because we're not targeting them because they're members of that group. We're targeting them because of their actions. How would you answer that?
Well, we'll get into this obviously later, but my response to that would be to say that there is voluminous evidence that demonstrates that Israel on October 7th and thereafter identified Palestinian society in Gaza as the enemy and repeatedly declared that it will observe no distinction between armed combatants and unarmed civilians. And
yes, but my dear barrister,
which I'm not, but I'll try to answer anyway.
I think you're missing the point. They're targeting them because of what they did, not who they are. The Genocide Convention is designed to prohibit crimes against national, racial, ethnic, and religious groups because of who they are. But in
Well,
this
and I
case,
think the South
Israel is
African,
targeting them because of what they did, which is different.
well, and I think the South African submission makes clear that in its actions, Israel effectively considers Palestinians, by virtue of being Palestinian, a legitimate target for its armed rampage through the Gaza Strip.
But a legitimate target because of what they did.
A legitimate target, not because of what they did, because the Israeli claim is that I think 1 or 2 thousand armed Palestinians entered Israel on October 7th. And clearly, not only do we now have about 23,000 dead and an additional 8,000 missing, a very large proportion of whom simply could not have participated in these attacks, either because they haven't yet started walking or don't know how to speak, or don't yet have the strength to carry a gun or a machine gun. And I think quite clearly the targeted indiscriminate nature, if you will, of the Israeli attacks demonstrates, along with numerous statements by Israeli leaders, that it was an entire society, because it was a Palestinian society, that is being targeted for destruction by the Israeli military.
Listen, I am not going to dispute any of your facts. For the sake of this presentation, I'm going to accept your numbers. And I'm going to accept every description you just put forth. But I don't think you've answered the legal question, because obviously Israel is not engaging right now in genocide in the West Bank. Can we agree on that?
In the West Bank, no.
Okay, so why are they engaging it in Gaza and not in the West Bank? It's the same people. They're all Palestinian. They're engaging in that genocide they are engaging in their assault in Gaza, not because they are Palestinian as such, but because of what happened on October 7th. Now, without quarreling with any of your facts, I don't think you're proving genocide. And that's what we're here for.
Well, one thing that distinguishes genocide is that there is no defense against it. In other words, it's not like the taking of a life, where you can claim justification for doing so on grounds of self-defense or a mortal threat or whatever. I mean, in genocide, why you did it, what the circumstances are, any extenuating circumstances are fundamentally irrelevant. You either did it or you didn't.
Okay. For the benefit of the viewers, the reason I wanted to put you through this little exercise is because this is how I think the proceedings are going to go. I think that the South African side is going to put the stress on the horrendous acts that occurred and say it's impossible for any sane, rational, normal human being to deny or diminish the magnitude of the horror that's been inflicted on the people of Gaza. That's going to be, in my opinion, we'll wait and see. In my opinion, that's going to be the thrust of the South African case. And that's basically, I think, what Mouin was trying to demonstrate now, that it was, as he correctly puts it, this is a targeted, indiscriminate assault on the infrastructure and on the population of Gaza. And I think that the Israeli case put forth by Malcolm Shaw, although it hasn't been revealed yet, we have no equivalent brief to the one submitted by South Africa. his case is going to be, I am not going to argue with any of the facts. That is not, even though I might not agree with them, and even if in lengthier proceedings, I think I could demonstrate a significant number of the facts are incorrect or exaggerated, I'm here to simply say it might be horrible, it might be terrible, it might be awful, but it's not genocide. Case closed. Goodbye.
And again, in whole or in part, so you don't have to prove anything about the West Bank or Lebanon or anywhere else. There are Palestinian communities, but
I would like to make just one more point. I do not believe it's accurate that you have to demonstrate a mental state exclusively by statements made. You can also infer a mental state from what's called the natural, inevitable result of an action.
Such as prohibiting the provision of food, water, medication to the Gaza.
Exactly. You don't have to say the reason I am denying them any food, water, electricity, or fuel is because I want to destroy them. You don't have to say that.
It's common sense.
If the inevitable and natural result of denying people those four necessities is the destruction of the people, then you're allowed under the law to infer intent from the natural and inevitable result of your action. Now, in the case of Israel, we do have a lot of statements. You know, they can already fill a volume, the number of statements that were made, which is also an interesting question if you would like to talk to me about it. Why they suddenly started to make all of these statements after October 7th. But even if we didn't have those statements, I don't believe that that means there's no case. You can infer intent from the natural and inevitable result of a particular action. It's like saying you take a gun to a person's head, right? And then you pull the trigger and you smash the person's skull.
And you claim you didn't intend to kill them.
Right, you were just testing the trigger. Is that a plausible claim? No, I didn't intend to kill them. I just wanted to see if the trigger worked. The natural and inevitable result of pulling the trigger is to kill the person, and then you can infer that was your intent.
Yeah. There's one other aspect here that I think we need to briefly at least mention. We don't necessarily need to discuss it, which is that the reason South Africa is bringing this case is because both South Africa and Israel have ratified the 1948 Genocide Convention, and the International Court of Justice is a forum in which disputes regarding the Genocide Convention is adjudicated. And South Africa is claiming that although the genocide that it asserts is being perpetrated by Israel does not affect South Africa, that South Africa, pursuant to this convention, has a positive obligation to prevent genocide by any other state signatory to the Genocide Convention. And in fact, it's not the first time that we see this, because several years ago, Gambia brought a case against Myanmar before the International Court of Justice on account of Myanmar's genocide against the Rohingya.
First of all, beyond what you just said, first of all, I think we should just take a moment of silence, as it were, to really pay tribute to South Africa. That was such a principled, courageous act in a world filled with so many cowardly states. Bear in mind, no Arab state went to the ICJ. Turkey didn't go to the ICJ. for all the wonderful things that the Latin American countries have done in solidarity with the Palestinians, we still have to acknowledge they didn't do it. Brazil didn't do it under Lula. It could have. It was really a wonderful sight to behold. It was a kind of tribute and residue of the spirit to fight apartheid. That bear in mind, for those of you who are younger than me, that was a real international struggle. And now South Africa is returning that spirit of solidarity of which it was a beneficiary in a different era. And let's be clear.
And that's your explanation of South Africa's motivations.
I would say we're talking about politicians. We're talking about states. They have interests. Let's not be starry-eyed, woolly-headed or woolly-headed about it. Woolly-haired about it, is that the expression?
Starry-eyed will do.
Excuse me?
Starry-eyed will do.
Yeah. However, granting that, we have to bear in mind it took a lot of courage, because you're not defying Israel, you're defying the United States.
Exactly.
And that's not an easy thing to do. And that's why none of the other states did it, because states look after what? They look after their interests first.
And in many cases, they're simply terrified of Washington.
Right. They're terrified of Washington because they're afraid of the repercussions. And for South Africa to do that, really, states have interests, no question about it, but it couldn't have been in their interest to go on a collision course with the United States. That's not in their, it's not the interest of any state in the world. The US is a very vindictive place. And Mr. Biden is a very vindictive person. So we should, in my opinion, pay tribute. I'll tell you the truth, Mouin. I was, like yourself, I was subjected to a number of queries about invoking the Genocide Convention. And I thought to myself, okay, it's another avenue, but let's be for real. What state is going to invest itself in this undertaking? I was completely shocked when I read the South African brief. It was so professional.
Yeah, and we'll get to that brief in a moment. But before doing so, we're about halfway through our discussion. Let's briefly explain to our listeners how the next few days are going to be structured. What is going to happen at the International Court of Justice? First of all, South Africa is bringing this case, in addition to the reasons you mentioned, because it is claiming that it has a positive obligation as a signatory to the convention to enforce it against another signatory, which is Israel. And it is claiming that a dispute exists between these two states about the interpretation of that convention with respect to developments in the Gaza Strip. Now, that having been said, what should we expect for those of us who will perhaps want to follow this a little more closely? What is at stake at this stage of the case? What will be happening during the next several days?
Okay. To your listeners, that I can speak to them directly, actually a lot is at stake. It's not just a judicial decision of which these bodies, be it the ICC or the ICJ, have issued a voluminous number. The important thing to bear in mind is, what is South Africa asking for? South Africa is not asking for a final determination of whether or not what's happening in Gaza is a genocide.
At least not at this stage.
Not at this stage. South Africa is not asking for that in the next couple of days. South Africa is asking for the following. They say if we have made a plausible claim for genocide,
Without needing to prove it.
not a definitive case,
Mm-hmm.
a plausible case, a believable case, a credible case. If we have made a credible, plausible case for genocide, then what we are asking from the court is what's called in the United States a temporary injunction.
Provisional measures in the language of the ICJ.
Yeah, provisional measures. That simply means we're asking the court, because we've presented sufficient evidence that something horrible is going on there, that you say they have to cease and desist now. We don't have to wait for a final determination by the court, which may take years, but you have to issue a temporary injunction to cease and desist now. And that could have very immediate consequences. In the case of the Gambia case you mentioned, I think the court issued its temporary injunction within 8 days.
Mm-hmm. And the purpose of the provisional measures being requested from the court by South Africa are actions that Israel either must undertake or must cease in order to prevent further irreparable harm, as South Africa puts it, to Palestinian society in the Gaza Strip, pending a definitive ruling on its claim of genocide.
Yes, the obvious point being, if you don't issue a preliminary injunction now, there may not be an injunction to issue later, because the genocide,
it'll be academic.
The genocide will have occurred.
Mm-hmm.
And I say personally, that's going to put the ICJ in a very difficult position, because it's impossible to read that brief submitted by South Africa, those 84 single-spaced pages, based almost entirely on UN sources.
And Israeli sources.
And Israeli, right? And very few Palestinian, incidentally, very few Palestinian. It's impossible to read that brief and walk away with the conclusion that a plausible case for genocide has not been made. In my opinion, and I do believe I'm being objective, I do not believe it's possible to conclude a plausible case has not been made. But I want to add something to that. The magnitude of the criminality that's been visited on Gaza is so staggering that it will be very tough for a judge to say, well, yes, it's true. 10,000 children are dead. 60% of the population is dying, is starving. 10 children a day are suffering from amputations, and on and on and on. And then say, but you know what? It's not genocide, so no temporary injunction. I don't see how any judge can preserve his or her face with a conclusion like that.
But having said that, it's not whether or not the court adopts. It's not, the question is not only whether or not the ICJ will order temporary measures, provisional measures. There's also a range of provisional measures that they could order. And these could range from a statement that all parties to the conflict need to respect the laws of war, to ordering an immediate and complete and total cessation of all military activity.
I personally believe that if Professor Dugard makes...
This is John Dugard, who will be arguing the case on behalf of the Republic of South Africa.
If he makes a persuasive enough case by piling on the horror on the horror on the horror and the horror on the horror, it will be very difficult for the court to say we are not taking any action beyond a statement. That would completely discredit the court in the eyes of the world. That's my opinion. That's why it's very important to have broadcasts like this, so the court knows the eyes of the world are on it. And I believe that Professor Dugard's strategy would prevail against the hyper-technical argument that Malcolm Shaw will attempt to make, that yes, it's horrible, yes, it's terrible, yes, it's awful, but it's not genocide.
But again, this is a legal case, obviously, and it's being argued.
It is and it isn't, Mouin. As
Well,
you know, it's a
yeah,
legal case formally, but it's a
yes,
highly politicized case.
precisely.
Really.
And if we look, for example, at the proceedings of the Security Council, and of course, recognizing that the ICJ is a very different organ than the Security Council, the United States in the Security Council has had absolutely no compunction about vetoing one draft resolution or a proposed amendment after another, calling for a ceasefire, despite the overwhelming facts of the case.
Well, there's
And
one big difference. The U.S.
there's
doesn't have a veto power in the
correct,
ICJ.
correct. But the broader point is that if an institution whose mandate is to preserve international peace and security can basically throw international peace and security into the garbage, there is, on the face of it, no reason that a court charged with upholding the rule of law and international law might take a similar political attitude
I totally
towards
agree.
mandate.
I totally agree.
Mhm.
And that's a real possibility. But that's why I said it's very important now for the public to be focused on it and for the people in the court to know we are watching you.
Mhm.
And if you do nothing, you are going to completely discredit the rule of law.
Mhm.
You will be shamed for your shameless action from now through eternity. So if they could do it behind closed doors, of course, they're all terrified of the United States. But I think in public, if Dugard is as effective as I anticipate he will be, I do believe they will have a problem saying you can continue what you're doing.
And as you indicated earlier, in the Myanmar case, the court issued its provisional measures within, I think, 1 or 2 weeks of the hearings. And in principle, we can expect a similar timeline in this case. And then afterwards, there will be the substantive case. In other words, the court, presumably having considered the South African allegations plausible, will then have to rule several years down the line, is probably how long it will take. We'll have to make a definitive judgment on whether Israel is or isn't guilty of genocide. So my question is the following. This case is, for various reasons, being described as not only significant, but historic, and even one that can potentially have an impact on the ground. But in a situation where there is a growing consensus among scholars and specialists that Israel is indeed committing genocide, and given that this court also is in certain respects a political court, what would be the consequence of the court ultimately deciding that this is not a case of genocide
Oh,
at the time?
it'll be a disaster.
Mhm.
It'll be a disaster if they say, um, it's not genocide because the message they'll be translating is it's not really so bad. That's the, whatever the legal technicality is, it's not genocide, it's a crime against humanity, or it's a war crime or a accumulation of war crimes. But the message will be, whatever the legal delineations are, the message will be it's not so bad and they can go ahead and do it. Even though, of course, you're not allowed to commit crimes against humanity. I would want to make the point here that this is the second great legal moment in the resistance to Israeli actions. The first, if I can call great, the first historic moment was the report by Richard Goldstone after Operation Cast Lead in 2008-9, because Richard Goldstone was a South African jurist, just like John Dugard. In fact, they're friends, or were friends. Also a distinguished jurist. But he had two characteristics that didn't apply to John Dugard. He's Jewish, and he is a self-identified Zionist. Personally, I don't like the term Zionist, but since that's his self-identification, he's a self-identified Zionist, and he's Jewish. Now, he delivered, like we're hoping from the court, after Operation Cast Lead in 2008-9, he delivered a devastating, scathing indictment of Israel, saying it was guilty of massive numbers of war crimes and some crimes which rose to the crime of crimes against humanity. Now, Israel—
And it was a very detailed report.
Oh, yeah, it's 400 pages. And Israel was terrified of that report. And there's reason to speculate, in my opinion, and I've given my arguments in print, that it was pressures applied to either Richard Goldstone himself or members of his family that coerced him into rescinding the report. But that report was very significant. Israel described it as one of the three main existential threats confronting it. It said Hamas rockets, Hezbollah in Iran, and the Goldstone report. As I've already said, they were forced to rescind. Richard Goldstone rescinded it. I think he did it from compulsion. He was coerced into rescinding it. But it's an interesting point, and if you'll just allow me quickly to go through it.
Please.
After the Goldstone report, before the Goldstone report, the Israeli leaders would make these most outrageous statements about what they were doing, sort of what they did after October 7th. They said, we're going to destroy everything in Gaza. We're going to apply what was called back then, I'm not going to go into the technical terms, the Jadaliyya doctrine. We're going to destroy everything in Gaza. And so when Richard Goldstone came along, he had an embarrassed riches. He had all these statements he reported. And after that, the Israelis were very cautious about what they said in public because they knew it could be used against them in a legal indictment. So in subsequent quote unquote operations, be it Pillar of Defense or Protective Edge in 2014, it was very hard to find a statement by Israel.
And here I need to interrupt you because what struck me on this occasion, obviously, on October 7th and thereafter, you have all the statements in the South African submission. But what's also struck me is that even after South Africa submitted its case to the ICJ, Israeli leaders continued making such.
And that's an interesting thing.
It's almost as if
they couldn't control themselves. Their id had jumped out. They couldn't control themselves. They were so seized by madness that even though they knew these statements could indict them, they couldn't control themselves.
That's one interpretation, that they couldn't control themselves. There's another interpretation.
I want to just hear you. I want to hear you out.
Yeah.
I just want to make the comment. Just today, I read in the Times, they targeted another ambulance.
Yeah,
You know,
killed 6. Yeah.
killed 6 people. They're targeting an ambulance the day before the indictment. They are seized. What my view is, they are seized by madness. They are out of control. But go ahead, your interpretation.
That's one interpretation. Another one, and the two are not necessarily contradictory, is that Israel has reached a level where it is sufficiently confident that Israeli impunity for its crimes against the Palestinians has become a basic principle of international law. They know they can do as they please, and the courts can rule as they will, but they will never be held to account for their actions. And it's in that environment that they have become incapable of self-control or inhibition.
But I don't want to get into a tit for tat here, but they did control themselves after the Goldstone report.
And having gotten away with it, and with so much else since then, they're no longer capable of observing restraint, no longer capable of conceiving a situation in which the impunity will end and they will be held to account.
I'm not sure. I'd have to think it through. As I said, you made a comment which I wasn't aware of. You said they continued to make those genocidal statements even after South Africa's submission. I hadn't followed it that closely, but I was struck today because the Times put it on the front, New York Times put it in the front page. They targeted another ambulance right in broad daylight.
And yesterday or the day before, a journalist, and it strikes me also that
what are the judges going to think?
and they're no longer
They
so
have fresh
often.
in their minds, the judges, when they come to the court in about 6 hours, they open up the newspaper and they say, this lunatic state is targeting ambulances the day before this hearing. I think they're going to have just a very tough time saying, well, it's not genocide. Have a good day. I'm off. I think they'll have a tough time with that.
And quite often, in this latest onslaught on the Gaza Strip, so often the Israelis no longer even bother going through the motions of making these claims about human shields and legitimate military targets and so on. They don't even bother anymore so often. And
only their international apologists use that argument. They actually themselves, they don't.
Yes. And your explanation for that is that they have become incapable of self-control or inhibition or restraint.
Totally out of control.
No, no.
Totally out of control.
And I agree, but my explanation for that is
the impunity.
When you know that you will always have impunity, when you are conditioned to believe that your impunity has become a fundamental principle of international law.
Look, I'm giving as positive a spin as I can. I want to give them a chance. John Dugard, I think he's 87 years old, if I'm not mistaken. And this is going to be his last act. And for those of you listeners who don't know, John Dugard was Nelson Mandela's lawyer.
That's right.
He was Bishop Tutu's lawyer. And he was also the special rapporteur.
United Nations Special Rapporteur on the situation of human rights in the occupied Palestinian territory.
He knows the law and he knows the facts. That's a very unusual combination. People who know the law often don't know the facts, and people who know the facts often don't know the law. He knows them, and he's as competent as anybody on God's earth, literally, to argue this case. So, for me, I want to remain optimistic that he's going to, it's what they call hope against hope. I want to remain optimistic. He's going to rise to the occasion, and he's going to finally put a stop to the horror that has been inflicted on those godforsaken people of Gaza.
Norm, a final question I'd like to discuss with you. What does this, we've discussed extensively of what this case may mean for the Palestinians and may mean for Israel. What will it mean for others? And here I'm thinking specifically of states like the United States, like member states of the European Union, those who have basically been in a state of permanent standing ovation about Israel's actions since October 7th. Does
Look,
this case have any bearing or consequences
yes,
for?
it does. First of all, I'm old enough to remember no country would dare defy the United States this way, except the Soviet Union when it was the official adversary in the world, whereby they were always defying the United States. And then there was a short period where people like Cuba, in tandem with the Soviet Union, but also independently, would defy the United States. But it's been a very long time before a country would dare defy the US the way South Africa is doing. It marks a calibrated shift in power, not a complete overhaul. But as you know, South Africa is a member of the BRICS. Brazil, Russia, India, China, and South Africa.
And now being expanded.
But you could say below the global powers, the United States and the EU and China, it's a secondary, but they're a secondary tier. But now it's emerging. South Africa has summoned the courage to defy the United States. I think that's an important development, and I think,
especially if they get away with it.
Yeah, I think a number of the countries in the ICJ are going to be thinking about that. Maybe we can finally give the United States its due by supporting South Africa in this undertaking, because that will mean we're important too in the world.
That's the
pawns of the United States.
That's the geopolitical dimension, and I think it's, needless to say, a crucially important one. But in terms of, let's say, the legal dimension, if the court does indeed next week or whenever it does adopt provisional measures, those will presumably have consequences not only for Israel, but also for those who have been supplying it with ammunition, weapons, diplomatic support, and so on?
I don't know the technical law on that. In the case of genocide, if you are an abettor or an enabler or a supplier of the genocide, in all three categories, of course, we're talking about the United States.
But not only the United States.
Not only the US. Who are the main countries now supplying Israel with weapons since October 7th?
Well, I believe Germany is.
That's what I thought.
The Netherlands is supplying spare parts for the F-35s.
There was a very cutting remark you saw by I think the Belgian foreign minister today. She said,
deputy prime minister, I believe.
Yes, she said, I hope Germany is not going to be on the wrong side twice. Excellent. And there's the wonderful Claire Daly from Ireland, who refers to that, I call her the Nazi princess.
Ursula von der Leyen.
Ursula von der Leyen calls her Frau Genocide. And I think those are all powerful, resonating statements. There is an element of indignation that has erupted, which I see as a very positive augury for the future.
And I can't.
And you know what? It's the right moment. It's 2.5 million people, or 2.3 million people, immured in a concentration camp, half of whom are children, who are the object of this genocide. It's simply incomprehensible that it should be allowed to pass. It's incomprehensible. If you look at all the studies that have been done since October 7th, comparing density of bombing, comparing numbers of UN personnel killed, numbers of healthcare persons killed,
Journalists,
numbers of journalists killed, density of destruction, every metric, literally every metric
was unprecedented.
Israel is off the map, and it's off the map against a population of 2.3 million people who have nowhere to run.
In a territory that measures only 365 square kilometers.
So Gaza has become the metaphor. At one point, it was Palestine, but now it's Gaza. That has become the metaphor for the wretched of the earth, the powerless wretched of the earth. So it's deeply inspiring when you hear a Claire Daly, when you hear the deputy foreign minister of Belgium. It's deeply inspiring, but on the other hand, it's warranted. It's warranted, this crime before our eyes, what has been done to those people, not just since October 7th, but that inhuman blockade that was imposed in 2006, those periodic mowings of the lawn. When you accumulate all of that, the cumulative result is such a horror that I can't see how the ICJ is going to just fold its hands and say, sorry, guys, it's terrible, but it's not a genocide.
And we'll find out in the coming weeks whether they do indeed have the moral and political and legal courage to do what's right. So tomorrow, in about 6 hours, as you mentioned, the International Court of Justice will convene. Its session on Thursday will be dedicated to the oral arguments by South Africa. Then on Friday will be dedicated to oral arguments by Israel. And that's essentially it. And then we'll have to wait to see if and which provisional measures the court adopts. And tomorrow, so at same time, same place, we will have listened to the South African arguments, and we'll be discussing and reviewing them tomorrow. Norman Finkelstein, thank you so much for joining Connections for this important discussion on the eve of the historic International Court of Justice hearings on genocide in the Gaza Strip.
And if I can say, thank you, Comrade Rabbani.
Thank you.
Okay.
So, I don't know how to stop this. Just a moment, please. If Bassam is with us, I can't find the stop button. Sorry, just a moment more.
No problem.
Hey, I can't seem to stop it. Yeah, thanks.
If you haven't stopped it,
Yeah,
I'm
it's
still
stopped.
watching, so I just wanted to warn you.
Yeah.